Good afternoon, everyone. Thanks for joining us. I'm Ashley Jordan. I'm a partner in the Labor and Employment Group of the Denver office of Husch, Blackwell, and we're so happy you've joined us today. Before we begin, I do want to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. We do welcome questions. We really want you to ask them. And if you have any during the webcast, please submit them via the question box at the bottom. We will try to answer all questions during the webcast today. But if a fuller answer is needed, then we will answer them later by email. A PDF of the presentation is available in the program materials folder, and the program has been approved for legal education hours. For live attendees, please report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. And towards the end of the program, we do ask that you complete our short survey. I know that time is limited, but we do take those seriously, and we hope that you will give us feedback that will help us plan future programs. So that's it for the housekeeping items, and now I want to go ahead and get started. Our topic today is Colorado's new limits on restrictive covenants. As you likely know, Colorado was already among the most restrictive states for enforcing covenants that limited employees' ability to compete and solicit customers after the end of their employment. Colorado's new law has limited these restrictions even further, introducing new penalties and notice provisions that are important for Colorado employers and multi-state employers who have employees in Colorado. And we want you to know about all of these new provisions. The webinar is going to discuss all the restrictions, identify the areas that still remain unclear, and also provide practical advice to you to ensure that restrictive covenants remain enforceable. I do want to add that my colleague, Chris Otley, was all ready to go in terms of presenting today. And unfortunately, he's not able to be here. He gave me permission. He said it wouldn't be a HIPAA violation in his mind for me to share with you that he does have COVID. Otherwise, I know he would be here even remotely, but he just does not feel well enough to present. He helped us with the materials. He was all ready to go, and it just didn't work out. But lucky for you all, I didn't think that you would want to hear from just one presenter for the entire webinar. So I was fortunate enough to get Barb Grandjean, who's one of our partners also in the Denver office, to help present today. I'm going to start the presentation, and Barb, she's on the camera, but she's going to join in a little bit later on. And with that, I'm just going to go ahead and get started. Okay, so let's go ahead and dig in here. I want to give some context first. I'm sure you're all aware with Colorado Revised Statute 8-2-113, also informally known as Colorado's non-compete law. It's been on the books for decades. It's very restrictive, one of the most restrictive in the country. States that a non-compete is presumed void unless it falls within one of the four exceptions that you see on the slide here. On top of that, there's a reasonableness test, and reasonableness in terms of geography, in terms of the time period, and in terms of the scope of the non-compete itself. So that's the law as it stands right now. But there's been a House bill that it goes into effect in August, and that will change this slightly and provide some more provisions. So just kind of going back to where we are now. So Chris, Barb, and I all have had so many matters, for a long time, for years, more years than we probably want to admit to, in terms of drafting non-competes, making sure that they're enforceable in those situations. Sometimes we're fighting against a non-compete. Sometimes we're just helping draft the agreement, and it's not even in litigation yet. So if you've been in that situation, you know that, there are many murky areas. What is reasonable is often very unclear. based on the case law. And so we have to use our best judgment there. And I know that for the three of us, one of the bullet points that is often at the center of a lawsuit is the bullet point of any contract for the protection of trade secrets. Because the question is, what is a trade secret? And that's very hard to prove. It's very fact intensive. And if you've been involved in litigation, you know that it's a very expensive endeavor when that is the issue. So in terms of geography, obviously the question is, is it a city? Is it a state? Is it the entire US? Is it worldwide? With duration, sometimes clients ask, is a few months okay? Is 6 months okay? What about a year, 18 months, or even longer? Obviously, the longer it goes on, the harder it is to enforce. And then what is the scope? The courts really want to make sure that you're not being overly broad. So want to get to what we're going to really focus on today now that we've kind of laid the groundwork of where we are right now. For today's purposes in the webinar, what I really want us to cover is what do you need to do right now? What are the action items that need to be kind of at the forefront on your to-do list? And then second, I want to talk about, and Barb's going to help me with this, on what you need to know in addition to topic one. What are the nuances that you need to know? What are kind of the special considerations that you need to be thinking about or just have knowledge about? And then three, this is, the frustrating part for all of us. What questions are still unanswered? What do we wish had been addressed in this new law? And what is likely to still be a topic that might be litigated? And so we will identify some of those as well. Okay, so let's see. All right, so the first topic is what employers need to be doing right now. And what I really want to focus on today are two areas. One is the highly compensated worker issue, and the second is the notice issue. And I'm going to break those down, and we're going to go through each one in quite a bit of detail. The first one with the highly compensated workers, that is something new in the covenant not to compete statute in Colorado. So now workers who meet a certain salary threshold and other requirements, if you have a covenant not to compete covering those workers, it's more likely to be enforceable. If they're not highly compensated from now on, it's not, the covenant not to compete just flat out will not be enforceable. And I'm going to go through exactly what I mean by highly compensated. And then second, there are notice requirements now, and they're pretty stringent. They're very detailed, and there's quite a few requirements. Lucky for you, before he got sick, Chris actually drafted one of these template notices that is one of the slides. So you'll have it in your materials and you can use it going forward. So we thought that would be helpful for you to have something to walk away with, and you didn't have to kind of guess what the notice should look like. Okay, so first, we're going to go into the highly compensated worker issue. So you see three circles here. They really should have an and in between them, because in order to have a highly compensated workers covenant not to compete be enforceable, you have to have all three of these circles here. So the first is that the highly compensated worker has to meet a monetary threshold. And right now, that's $101,250. So it's this salary designation plus the non-compete has to be for the protection of trade secrets. Obviously, that's still going to be an area of a lot of conflict, a lot of litigation, specifically what is and what is not an actual trade secret pursuant to applicable law. But beyond that, you also, even if you have the monetary threshold, even if you have it for the protection of trade secrets, you cannot be overly broad. The covenant has to be drafted in a way that is reasonable to protect the employer's legitimate interest. It can't be overly broad to do more than it needs to do. So in other words, that those words reasonably necessary are also going to continue to be fraught with conflict. what is reasonably necessary. And obviously that is different in the eyes of every beholder, including in different courts. So those are the three requirements making up a highly compensated worker. Now you might think, does this really change anything now that we have this salary threshold? We don't think it really does, because we think it was probably unlikely that an employee making less than six figures was going to truly be subject to a covenant not to compete that a court would enforce. So I don't know that it really changes a whole lot, but it does add something for your to-do list now, which is, if you're even thinking that you want to have a covenant not to compete with someone going forward, they at least have to make this salary. So that's something to think about. Now, and I guess also I should mention, while you're thinking about things to do now, you want to look at who you have covenants not to compete with and who you might want one with in the future. Maybe there's a new employee coming on board. You want to make sure they're going to make that salary figure. But you might also want to go ahead and think about, is it actually true that this covenant not to compete is necessary to protect trade secrets? Because if it's really not, then even if the employee makes six figures, it's just not going to work. So maybe this is the time to think about that. Think about the factual scenarios that would come about if you were to be challenged on this, and maybe make some changes to show that, yes, these really are trade secrets, and we treat them as trade secrets, and we have things in place at our work site or with the employees to show that we consider them trade secrets. So all of that is just a good thing to kind of review right now in light of the new statute, or the amended statute, I should say. The threshold must be met both at the time the covenant is entered into and at the time it's enforced. And then you might be wondering, and I'm starting to see some questions come in, well, what constitutes the monetary threshold? And the answer is that it's the amount of the worker's gross salary or wage amount or other compensation for the entire year. And so that's for that's for workers who work for the full year. The covenant not to compete can still be in effect for workers who only work part of the year. And there, in terms of the monetary threshold, you would look at the worker's cash compensation, and if it would be deemed to be exceeding the threshold amount if the worker would reasonably expect to earn more than that threshold amount during a calendar year. So again, you have that word reasonably. It's a little bit of a gray area. It's a little bit subjective, but that's where the court has landed on that. Or I'm sorry, where the Senate has landed on that for the bill. If you're wondering where the $101,250 came from, that actually just came straight from the Division of Labor Standards and Statistics in Colorado's Department of Labor. That's the current monetary amount for what is deemed a highly compensated worker within the Department of Labor in Colorado. Obviously, that number will go up each year. It's subject to change, but that's where it is right now today. All right, and I'm trying to read questions as they come in. I do see a question here about whether other states have recently passed laws to avoid non-competes for lower wage workers. And the answer is yes. There are few. There's not a whole lot, but I'm aware of a few. I know that the income threshold is not uniform, so there's nothing magical about this $101,000. For example, I believe it's New Hampshire. They have a monetary threshold, but it's way down there. It's like $30,000 or something. And I think Illinois is at $75,000. And then there's a handful of other states, but Colorado's not the only one, but it's definitely the states that do have this, they're in the minority. Okay, so we've covered the highly compensated worker. in terms of what you need to do now and be aware of right now in terms of a to-do list. The second is the notice requirement. And so just want to be really clear, even if you meet everything else to make this covenant not to compete enforceable, if you don't have the right notice or if you don't have a notice at all, then the whole thing is going to be void. So it's really important. And it's really easy because we've already given you a template for it. So with this law, restrictive covenants are void unless there is a separate notice to the worker of the terms of the covenant. And this is all brand new. We haven't had something like this in the past. And it's very detailed. There's a lot of bullet points within the new law. It's pretty tedious, but when it comes down to it, the notice can just be a one-page document. You just want to make sure you cover all the points that are required to be covered. So again, even if the covenant not to compete is reasonable in terms of time period, geography, scope, even if it meets one of the exceptions, if you don't have this notice requirement, you're out of luck and the whole thing is presumed void. So let's go through what the requirements are. So you have to present the notice 14 days prior to a new employee coming on board in order for it to be effective. You can also provide a covenant not to compete for a current employee. And again, that time period is going to be 14 days before the effective date of any additional compensation or changes in the terms or conditions of employment that provide consideration for the covenant. Really importantly, the worker has to sign the notice. No one wants to see this thing where, the employer says, well, I gave them the notice or it was posted or something like that. It literally has to be signed, and that's a good thing, I think, because it protects both sides. Pretty interestingly and definitely significantly, the notice must identify the agreement by name, and it must state that the agreement contains a covenant not to compete that could restrict the worker's options for subsequent employment following their separation from employment. So it's very straightforward. It states on the notice and gives the worker the language that, yes, this can affect you following the separation of employment. No one's thinking about that when they're coming on board. And so part of the purpose of the notice is to say, hey, just in case things go sour, or just in case you have this other opportunity that you can't pass up or something like that, we want you to be aware now of what happens then. The notice cannot be part of another document. So gone are the days where maybe you kind of bury this within some other document, and the employee comes back later and says, I didn't even realize there was a non-compete. I had no idea. It now is very specific. It can't be buried in something else. It has to be a standalone document. And it also has to use clear and conspicuous terms. This is not the time for legalese and to be overly lawyerly in wording. It's supposed to be very straightforward for the employee to be able to understand everything. And the notice must direct the worker to the specific sections or paragraphs of the agreement that contain the covenant not to compete. And that'll be a little bit more clear when I show you the sample notice. But you're literally in the notice going to be pointing to, with a paragraph number, where this non-compete language is, so that it's very, very clear for the employee to be able to go directly to that language and review it per the notice. A copy of the notice and the covenant not to compete both have to be given to the employee. And if a worker wants another copy, they're allowed to ask for it, and they're entitled to get it once per year after that. Now, you may recall that Colorado's had some other interesting and stringent requirements lately, and recent changes in employment law, such as the compensation job posting requirements. And so this is just another one of those Colorado-specific regulations that's in effect, that you want your in-house team to know about, you want your management team to know about, you want your HR people to know about, assuming that they are involved in covenants not to compete. And especially with workers working remotely these days and not always working in the same state where the employer is located, these are things to know about. You want to make sure that you are following Colorado specific law if there's a Colorado worker. All right, and I'm seeing another question here that I'm going to answer. See, it says, I'm a multi-state employer. Do other states have a notice requirement like this? Yes, there are a handful, not very many. And I'm not aware of any other states requiring a separate notice, a signed separate notice like Colorado does. But there are a few. I believe Illinois it's there again, just like we talked about Illinois before. I think Arizona and Oregon and Washington as well. They don't necessarily have the 14-day requirement, but I actually believe that is a pretty general time frame in the other states. But again, it's a handful of states that have these notice requirements. Okay, so now I want to show you what Chris was kind enough to draft before he contracted COVID. I hope you can see that. I know that it's kind of a lot of content for one slide, but honestly, we wanted you to have it. And when you get the PDF of the presentation, you could just print this out and put it on your own letterhead and tweak it as needed. So you'll see here that the employee is signing down at the bottom that he or she has received the notice as well as the referenced agreement. I like how there's a date on here so that you can see exactly what the date that the worker got it. I also like that there's a place for an employee name and just not the employee signature. There's so many times where there's some scribble for a signature and it's hard to necessarily know who that belongs to. And so to have a printed name is helpful. And then you'll see, all the bullet points that I just talked about, they're all incorporated here. You have the right title at the top. It's flat out says this is a restrictive covenant notice and acknowledgement. And then it's in very clear terms. It's not legalese. And then see in the middle where you have the 4 dashes, those are next to what agreement might be referenced in terms of this notice. And you'll see the top one is covenant not to compete, which is the agreement that I've been talking about a lot. But there's also places to reference a non-solicitation of customers, non-solicitation of employees, and a prohibition on the use and disclosure of confidential information. Those are also needing notice, and I haven't talked about those with you, but Barb is going to address those in a bit. So I just wanted you to know it's not something I forgot. We're going to get to it in a little bit. But in terms of this notice, you can have all 4 checked, you can have 1 checked, or somewhere in between. But you need to say which section of the agreement contains these restrictive covenants. It has to be so easy for the employee to look at this notice and then go straight to the agreement for reference. So I think that that's it in terms of the notice. Okay, and I'm seeing another question here. In terms of action items, should we be doing anything about non-competition agreements that we already have in place? Great question. I believe Barb is going to address that in a little more detail, but I'll just go ahead and spill the beans a little bit right now. Just so you know, in case you're just wondering, right now, oh no, what do we do about prior agreements? The new law doesn't make past agreements unenforceable per se. It's not a retroactive type law, but at the same time, it doesn't protect those agreements that are already in effect, or hopefully in effect if you're the employer trying to enforce it. They just simply would be looked at with the old law in mind. So a caveat, though, I guess, to that would be if you're thinking about renegotiating a covenant not to compete, then you should be doing that with this new amended statute in mind. Okay, so now I think I've pretty fully covered what you need to do now, and we are going to talk about what else do you need to know. And so the first is, and you've probably picked up on this, there is no longer that standalone exception for the protection of trade secrets. Remember in the very first slide, I showed the bullet points of what constitutes the exceptions right now. Well, starting in August, you don't get to have a non-compete just for the protection of trade secrets. It's only if you have a highly compensated worker and for the protection of trade secrets. And so that is a change. And then, let's see, there's no longer the exception for executive and management personnel and professional staff. I have to say that this was often an area that was litigated, and we're not really sure why it's just gone now, but it is. So that has been nixed. What else do you need to know? You might be thinking, especially if you've been involved in briefs on this issue or litigation on this issue or just done any research, that there's an awful lot of case law, both at the state level and the federal law on this topic. And, what about all of that, especially with respect to what's reasonable in terms of duration, geography, and scope? And the General Assembly just flat out said at the very beginning of this bill, we're not intending to change the case law. The case law is preserved. And so that's still a resource, especially for arguing what is and is not reasonable. So just wanted you to know that that still is in effect. And then you might be asking, well, besides that trade secret exception, there were 3 other exceptions that Ashley had on her very first slide. What about those? So there still are exceptions in effect. One is the recovery and expense of education and training and repayment of a scholarship. And then, of course, still the purchase and sale of business. And then reasonable confidentiality provisions. There's some nuances here. I think Barb was going to pick up on some of those, and then perhaps just after that, go ahead and talk about some of the other things that we think that you need to know and address some of the questions still outstanding. So I think this is probably a good place for me to stop and let Barb take over.
Okay, thank you, Ashley. And I feel like since I'm pinch hitting for Otley, I should do some sort of imitation of him or something. But fortunately for you guys, I'm not. Unfortunately for Chris, I'm not much at imitations. I did, just before we change this slide, wanted to elaborate on a couple of the provisions that are still the same, but yet have changed. So I know we have a lot of healthcare people on this webinar, and we use this all the time in the healthcare industry, agreements that the employer uses to recover the expense of education and training of workers. And as it was originally drafted in the statute, it said that you could recover expense of educating and training an employee who has served an employer for less than 2 years. I don't think there's any case law on that old language, and I always worried that it meant you could only have a provision like this if someone was in their first 2 years of employment with you. The new law, however, has really clarified a lot of things. And so now under the new law, the 2-year period specifically runs from the completion of the training at issue. So that's very good news. It also allows you to recover the expenses, but you have to do it over a 2-year period of time, reducing it on a monthly basis. So you can't wait till the end of 2 years and say that your employee has to pay back everything. And then the third thing that it does is it clarifies that what you're allowed to recover as an expense has to be something that's distinct from normal on-the-job training, and it has to be limited to the employer's reasonable costs. And I think we always understood that was the case. This isn't the place where you can shift the cost of your overhead to your employees. It's got to be some additional extra cost that you've incurred in providing some kind of specialized training to your workers. So good clarification there. I think the other thing that I wanted to point out before I flip to the next slide is that the statutory provisions for non-competes between physicians, those have not changed. It's still in the statute, no clarification, no changes. But I do think that employers of physicians are going to have to think about the impact of the removal of the general exception for executive and management personnel and professional staff. That's no longer there. So I think you're going to have to think about what's the other basis for having some sort of a non-compete between physicians. And the way the statute's drafted, I think that's going to have to be trade secrets or in connection with the purchase and sale of a business. So I just wanted to highlight that for some of our healthcare folks. The new law, as Ashley mentioned, restricts covenants not to compete that are entered into or renewed on or after August 9th of 2022. There is an interesting provision in the law, though, that says the 14-day notice that Ashley was referring to also has to be provided to workers, and maybe it's a worker with a previous non-compete, an older non-compete, when their employment terms and conditions change on or after August 9th. So for example, if somebody gets a raise, I think there's a question of whether that triggers the obligation, at least to provide the notice in connection with the non-compete. Workers who have non-competes predating August 9th, and the ones post-dating August 9th may be viewed differently. So if you have a group of people leaving together, it'll be interesting to see how that gets treated if some of them have the old school non-competes and some of them have the new ones. And as employers, the most important thing for you right now is to keep track of which version of the law applies to which workers. And then I think we need to see how the courts and others expand on that. I think that your key piece right now is to focus on your new employees who are going to have new non-competes, because as Ashley mentioned, you do have to give that 14-day advance notice before they accept your offer of employment. So be focusing specifically on your new hires. And then, I think we'll have to see how this impacts existing non-competes if there's a change in the terms and conditions of employment or in the consideration that's being paid to the worker. The new statute also does have a provision in it related to the non-solicitation of customers. That was not in the old version of the statute. These types of non-solicitation agreements are usually used by employers to try to prevent an employee not from working for a competitor, but from soliciting customers or other contacts that that employee gained information about or access to while they worked for you. The new law allows generally for those types of agreements, but it also does put a compensation threshold on the people that can be subject to those. So for a non-solicitation of customers, the worker has to be making at least 60% of that highly compensated worker threshold that Ashley mentioned, which is, I have the math, $60,750 annually. So, and that's just in 2022. And remember then that floats, this highly compensated worker amount floats. But for now, as long as they're making 60% or more than $60,000 a year, you can have an enforceable non-solicitation of customers. I think where this typically comes up is in the context of sales. And I think it's a recognition that salespeople that employers of salespeople should have the ability to protect customer relationships in addition to or as trade secrets. This new law also talks about confidentiality agreements, which was not addressed in the old law, but is a pretty standard provision generally recognized by the courts and in virtually every agreement that you would see. The new law talks about the confidentiality provisions being enforceable so long as they are reasonably tailored to protect the employer's confidential information, and so long as they do not prohibit disclosure of information that arises from the worker's general training, knowledge, skill, or experience, whether gained on the job or otherwise, information that is readily ascertainable to the public, or information that a worker otherwise has a right to disclose as legally protected conduct. So That is an exception that is often found in confidentiality agreements that we see even today. So the general idea is that you can't protect a worker's general knowledge or information that they have developed about the industry through their own skill and experience. The only thing that you can protect as the employer is information that is proprietary and confidential to you, essentially. So at a minimum, I would recommend that any confidentiality agreement that you have people sign specifically includes this carve out, a recognition that you are not attempting to protect information that the worker has generally about their business and their industry and their experience. Some other things that Colorado employers need to know. Most non-competes involving Colorado workers are now going to have to be resolved under Colorado law and in the state of Colorado. So gone are the days when large employers outside of Colorado, maybe they have their headquarters in New York, have a cookie cutter agreement that they give to all of their workers that has a New York choice of law provision and a New York venue provision. The employers would say that's for consistency so that their agreements get interpreted the same way by the same courts under the same law. You can't do that anymore by statute in Colorado. I would say generally that the courts spend a lot of time, even with those agreements, trying to decide whether the choice of law in the agreement is reasonably related to the work that the employee does. But now, by statute, it has to be Colorado law and in Colorado. So under this new law, the test for the choice of law, what state's law is going to govern the non-compete with the worker. The question is, at the time of termination of employment, which is when the employer wants to enforce the non-compete, did the employee primarily reside and work in Colorado? If the answer to that is yes, then Colorado law governs the dispute. So I was trying to kind of play this out, getting ready for the seminar today. And so if an employee lives in Colorado, but works in Kansas, so they just drive across the border each day, I think there's still an option for an employer to apply Kansas law because you don't have residence and work in Colorado. You just have residence and not work. But if the employee lives in Colorado and works a territory that includes Eastern Colorado and Western Kansas, then Colorado law would govern that relationship because in that hypothetical, the employee both primarily resides and works in Colorado. The test that is set out in the statute now about the location for any dispute is a little bit different. So again, at the time of termination of employment, when the employer wants to enforce the non-compete, the question is, does the employee primarily reside or work in Colorado? There's not an and, there's an or. So in that instance, if you live in Colorado or you work in Colorado, the dispute has to be resolved in Colorado. So back to my hypothetical, if you play it out, we have the worker who lives in Colorado, who drives across the border to Kansas. I think that the way the statute is written is that worker has the right to demand that a dispute about their non-compete be decided in Colorado because they primarily reside in Colorado. I'm not sure if that's what the legislature intended, so I think it's going to be interesting to play that out. So I see here's a question. What if the employee resides in Colorado but has equal territory in Kansas, Colorado, Utah, and New Mexico? So I think the question is for choice of law in this hypothetical, the person has work in Colorado and they reside in Colorado. So the question, they definitely have primary residence in Colorado. The question is going to be, do they also have primary work in Colorado? It's a good question. Maybe it ends up being a fact dispute, but I would say in terms of what jurisdiction decides that dispute, because your person in your question primarily or exclusively resides in Colorado, I think they get to have the choice to have the dispute resolved in Colorado. There's also penalties in the new statute. So there's a $5,000 penalty if an employer enters into a non-competition agreement that is void or attempts to enforce one that is void. That aggrieved applicant or worker can get a $5,000 penalty. They can also get injunctive relief as appropriate, actual damages, and attorney's fees. The Attorney General can also bring claims under this statute. So again, gone are the days where an employer might say, yeah, I have this really overbroad, aggressive non-compete. I know you're telling me it's not enforceable, but let's just get everybody to sign it and we'll cross that bridge when we come to it. I think that employer is at risk of fines and consequences by sort of bullying the employees into signing something that the employer knows is not enforceable. And I'm sure none of the employers on this webinar would do that, but I have met some in my past who might consider it. The law also provides for a good faith defense now, and it's a good faith defense as to the penalty. So if the employer can show that they had good faith and you had a reasonable basis for believing that the non-compete was enforceable, then the court can decide whether or not to award the penalty. And I think there's a couple of ways to look at this. On the one hand, as Ashley mentioned, there's tons of case law, and so there should be some certainty in terms of what's enforceable or not enforceable. On the other hand, though, it ends up being a very intense fact dispute. And so you may not win even though you think it's enforceable. So I think that this is an opportunity for you to consider documenting the decisions that you're making and the good faith nature of your decisions. So maybe you are looking at non-competes on an annual basis. And let's say you have a checklist and you go through the non-competes each year and you say, okay, yep, they're still highly compensated. Yes, they still primarily reside outside of Colorado, however you want to phrase the checklist, but something to show that you are aware of this and you're considering the agreements you have and modifying them as necessary in good faith in accordance with this new law.
Hey, Barb, I was just going to add one thing on the good faith defense. Another thing that that employers out there on the webinar might want to think about doing is documenting any kind of training that you're doing for managers or HR or in-house. I mean, even attending this webinar would be a plus. But going back to your place of work and really making sure that other people who are involved in any of these restrictive covenant negotiations or discussions also know what the new law says. And if you document that, I feel like that could be helpful.
Yep, that's a great thought. Okay. So then the questions unanswered. Ashley said she wished they'd been answered. I kind of like that they're not answered because it gives us a chance to debate and argue and wonder and watch and write follow-up legal alerts. But the first question that is kind of unanswered, or at least is presented by the modifications to the statute, relates to the concept of consideration. So without getting too lawyerly, all contracts of any kind have to have consideration, which basically means both parties get some benefit or the parties forego some kind of a detriment, but there has to be some value that's provided in connection with the agreement. So in the context of a non-compete agreement, the Colorado Supreme Court has historically held that continued at-will employment is sufficient consideration for a non-compete. So the fact that you sign a non-compete and I let you come to work as an at-will employee the next day, assuming that I'm not trying to pull a fast one, that's sufficient consideration for that non-compete to be enforceable. And so this new law talks, as I mentioned earlier, about this idea that it can be triggered when somebody has a change in the terms and conditions of their employment or in their compensation in a way that could be consideration for a non-compete. So I think there's an interpretation of the statute as it's now written that if there are changes to compensation or terms and conditions of employment after August 9th of 2022, that you would be obligated to provide at least the required formal notice that Ashley talked about. What I don't know, and I think remains an open question, and I think it's a question that a whole bunch of you are asking, is what happens when somebody has an existing non-compete, August 9th comes and goes, you give them a big raise on October 1st, you give them notice as required under the new law. What law applies to the non-compete, the old law or the new law? I think the statute is intending to say that it's the old law, but the way that it deals with the concept of consideration, I think it leaves open a question. So hopefully we'll get some clarification on that, but I think that's some confusion in the way that it's drafted generally. The new law does not talk about the non-solicitation of employees, which is another kind of covenant that we often see coupled with non-solicitation of customers and non-competes. I think the fact that it's not in the new law, it wasn't in the old law either, so I don't think that the legislature intended to address the non-solicitation of employees one way or another. That's typically something that courts are more likely to enforce, but I think they're super hard to prove because the existing case law on non-solicitation of employees essentially requires that there be some sort of active solicitation. And I think where the fact disputes often end up here is that maybe the new employer or the new employee on behalf of the new employer posts publicly a job opening and people from the former employer respond. That wouldn't necessarily be active solicitation. And so that probably wouldn't violate a non-solicitation of employees. But remember that that's a tool that's out there, and I don't think it's impacted by this law that we're talking about today. Another big potential change, maybe, is that this statute talks pretty consistently, almost exclusively, using the title worker and not employee. And so while there is no mention of independent contractors in the new law, I think the fact that it uses the word worker means that you should assume, if you're going to take the conservative position, that independent contractors would also be subject to the same requirements under this law, certainly for non-competes. I think another open question, the way that this law is drafted is it's unclear whether some of the provisions like Ashley was talking about for notice apply only to non-competes or whether they also apply to the non-solicitation of customers or confidentiality agreements. I think the position that we're taking, and certainly in the form that we provided to you, is that those things might be covered and might require notice. And so why on earth wouldn't you go ahead and just give the notice? It doesn't do any harm. I think then the last point, and maybe we can get to a few questions, the last point I wanted to make is, again, some pitfalls for multi-state employers. So I think that these choice of law and venue provisions are going to create potential problems for the remote workforce and employers who have workers all over the country. So, for example, if we have an employee who's hired in Texas and she works at the headquarters in Texas and she signs a non-compete in Texas, when she starts there, she decides she's going to move to Breckenridge and work remotely. And the agreement she has a choice of law and a venue of Texas. I think after August 9th, when she moves to Breckenridge, the court's very likely going to apply the Colorado choice of law and also the Colorado venue provisions for where disputes need to be resolved. But in my mind, in my hypothetical, this Texas employer hasn't called Colorado counsel. And so chances are good that her whole non-compete gets thrown out altogether because the employer didn't provide her with the requisite notice that's needed in Colorado. So I think that multi-state employers are going to have to think carefully about that. And I think that non-competes are now something that fall on HR's plate, not as a one-time sign the employee agreement, stick it in a drawer and see if we need to use it when someone leaves. It's going to be more of an ongoing monitoring compliance type issue. I had suggested annually, but If you've got people that are moving all over and working in different states and traveling, and it's really important for this reason and for a whole bunch of other reasons that the employers know where their employees are so that they can be in compliance with the applicable state laws. And this is a great example. If you want to enforce that non-compete for the employee who is now primarily working and residing in Colorado, you're not going to be able to do that on your old Texas form when you haven't given notice. So with that ends my prepared comments. I don't know, Ashley, if you've had a chance to peek at any of the questions. I saw a few of them related to this topic, and so let me take this and I can answer it. But there are a lot of questions about how you compute the compensation threshold for the highly compensated workers and what's included in that. And so according to the statute, I'm reading right from the language of the statute, we're looking at annualized cash compensation, which is the amount of the gross salary or wage amount, the fee amount, or the other compensation amount for the full year if the person was employed or engaged for a full year. So for employers that are thinking about someone who's paid on a commission, for example, I don't know what the answer is. I might guess that if the commission salesperson made above that threshold last year and they make above that threshold in the year that you're going to be enforcing the non-compete, you may fall within the statute in terms of being able to enforce your non-compete. But this does not directly deal with commissions or other kinds of variable compensation. So I think that is an open question on that topic.
Yeah, I agree with that. I think that there's still some things that are going to be fleshed out. I'm assuming that that type of question is probably going to be confronted sooner rather than later because it's a question that we've all thought about. I'm looking at the questions in the Q&A on this webinar, and there's several just on this topic. So you have to think that other people are thinking about it as well. And the new bill is just not specific enough to answer that fully.
And so here's another question that someone has asked. Do we need to provide notice to employees if we are no longer enforcing previously valid non-compete agreements? And the answer to that is no. If you don't intend to try to enforce the non-compete agreement, then I don't know why you would give the notice. I suppose if I play devil's advocate with myself, by leaving an old non-compete in place that you have no intention of enforcing, are you somehow putting yourself in a situation where you might be subject to a penalty or a fine? I don't know if that plays out, but generally the reason for the notice is so that you don't automatically have a void non-compete that you can't enforce.
So I see a question that asks, so will employees hired previously making less than this threshold no longer be held to the non-compete? So what I would say there is that, remember, this bill moves forward. It's not looking back. And so this threshold only applies to covenants not to compete that are being handed out basically on August 10th or later. So that whole discussion about the threshold, the salary threshold or the compensation threshold, it really doesn't apply to a prior non-compete that has already been signed or has been presented prior to August of this year.
So here's a question about employee handbooks and how that ties into the notice requirements. As a general matter, I would say if you have a non-compete or a non-solicitation, and maybe even a confidentiality agreement in a handbook, you're going to have a difficult time enforcing it as an agreement. Handbooks often say this is not an agreement, it's just information about our policies. So a non-compete certainly needs to be in a standalone agreement that is specifically signed outside of the context of a handbook. If you take our thoughts and the form that we prepared and you provide notice to the employees not only about non-compete agreements, but also about non-solicitation and confidentiality agreements, I would think you probably could reference for the confidentiality provision, for example, to your handbook. But I think you want to consider whether something like a confidentiality agreement should also be a standalone agreement that you can actually go and enforce, as opposed to just a provision that's in a handbook that, you know, might be the basis for a termination of employment, but it's not itself necessarily an enforceable agreement.
I think that about covers the questions that we can answer quickly and easily, because we only have a couple of minutes left. I guess I'd just like to thank all of you for being here today and giving Barb and I the opportunity to talk to you about this new bill. And then I do have just a few things that I've been told that I need to remind you of. You can get legal education hours for this. All you have to do is report your hours by clicking on the CEU button or icon at the bottom of the screen. And then tomorrow you're going to get a certificate of attendance with the course number by email. And you'll also get a recording of the webcast for watching and sharing. Also, I forgot earlier when I was talking about getting the notice that was drafted. You can access that in the program materials as well. And then we would like to be sure that you all complete our short survey. We really do value your feedback, and we'd love to hear what was helpful or not helpful, or any tidbits of information that we could use going forward, because we do quite a few of these webinars, and we're always looking to improve and really to touch on topics that are most useful to you. So with that said, this concludes our webinar, and thank you again and have a great day.